Good afternoon. It is officially afternoon. Welcome. Can everyone hear me okay? Thumbs up. So wonderful. Excellent. So I'm Amy Sings in the Timber. I have the great pleasure to serve as the executive director of the Montana Innocence Project. And I'm excited to have folks here today to listen and potentially engage in some conversation if we have some time at the end for questions. I want to just go over a little bit of housekeeping. Today's call is being recorded, and so I just want to make you aware of that fact. We intend to make our recording available on our social media channels for folks who aren't able to join us for lunch today. And we ask that you keep yourself muted during the panelist discussion. We've got a lot to get through and want to make sure that we are able to do so in a smooth fashion. And then just lastly, if you do have questions as we're going along, you can feel free to put those in the chat. And as I said, we're hoping that we might have just a few minutes to address some of those questions at the end of our discussion today. So without further ado, I will very briefly introduce our panelists for today and then allow them some time to give a little bit more background. With us, we have Caitlin Boland Aarab, and Katie is a partner with the firm of Boland Aarab in Great Falls, Montana. We also have with us Colin Stephens, who is a partner with the firm of Smith & Stephens in Missoula, Montana, and Andrew Huff from the law office of Andrew Huff in Helena, joining us from Helena. In addition to all of our panelists having in common that they are criminal law practitioners in the state of Montana, they are also all have the distinction of being board members of the Montana Innocence Project. And so we're so grateful to have such talented and really generous of their time board members serving for us as well. So just want to kick off but with introductions, deeper introductions for everyone. And we'll start with Katie. Katie, before we discuss cases, could you please introduce yourself, maybe tell us a little bit about your practice background?
Sure, Amy. After I graduated from law school, I clerked for 2 years, 1 year at the Montana Supreme Court and 1 in the Ninth Circuit. My husband and I then opened up a private practice in Great Falls. We've been doing that for 5 years now. We practice civil plaintiffs work, criminal defense in every jurisdiction, federal, state, trial courts, appellate courts. So that's highlight of my background.
Excellent. What made you decide to speak today? Why is it important to understand these recent Supreme Court decisions and their impact on the criminal legal system?
I think if you consider almost every right we have as an American citizen, people can name the cases that conferred that right. Roe v. Wade, which is no longer in existence, Miranda, Katz, Gideon, Brown v. Board, a lot of Americans can name some of these cases. And the point is that we have Supreme Court cases because something unconstitutional happened to a regular person, and that issue gets litigated. And I think it is organizations like this play a big part in educating the public about their evolving rights. And that's why I decided it's important to understand the most recent cases today, because they are evolving rights.
Thank you, Katie. Andy, I'm going to go to you next. If you could please tell us a little bit about your practice area and why you felt it was important to talk today on these issues.
Sure. Can you hear me? Okay. So my name is Andy Huff. I'm a private attorney in private practice here in Helena. As part of my practice, I do a lot of criminal defense work in federal court. I'm also an enrolled member up at Rocky Boys Reservation. I'm Cree. So another part of my practice is Indian law. So I've represented tribes as part of my practice. I've defended Indian clients in federal court, and also I do some trial judging work for Rocky Boys up on the reservation. So that's kind of my background and why I'm here today. I think it's important, these three cases, for a few reasons. One is, for me, it raises all three cases raise real concerns about rule of law and the kind of stability of the legal framework in this country. I also think, in particular, the Castro-Huerta case that I'm going to talk about has huge implications for tribal sovereignty that I'm concerned about. And it also has implications for wrongful convictions, which aren't immediately obvious. But I think because of that case, there's going to be an increased probability of both pockets of lawlessness, but also wrongful convictions in Indian country.
Thanks, Andy. Appreciate it. Colin, same questions for you. If you could just highlight a bit about your practice background and why you think it's important to discuss these cases today.
Sure. My name's Colin. I'm sort of a partner now at our new law firm of Stevens Brook. Amy and I graduated from law school together some time ago, and I'm on the board of MTIP. I chose Shinn in large part because I was asked and my ego dictated that I say yes. I'm also a bit of a habeas wonk. So, I mean, I guess I'll qualify that with I'm not as big a habeas wonk as Deb Smith or Christina Neal, both of whom are on this call and should avoid from calling me an idiot. So Shinn, as I'll get into, is important because it sort of just highlights the ever-growing Hieronymus Bosch painting that is the dismal habeas corpus practice in the federal courts. So I'll get into the bleakness of that a bit more in my presentation.
Thanks
Anything
so
else?
much. Nope, that's great. Thank you. All right. So we'll just jump in. I do want to give one more housekeeping tip, because we're in this, if you're in a multi-pane view, our panelists may appear very tiny. If you go to your view and select speaker, then each of them should appear much larger on your view screen. I'm going to start with Katie today and the Dobbs case. So Katie, can you give us an overview of Dobbs v. Jackson Women's Health Organization decision?
Sure. The two cases that Dobbs overruled, just so everybody knows, is Roe v. Wade, which until June 24 said that the due process clause of the 14th Amendment protects a woman's right to have an abortion prior to fetal viability. The other case is Planned Parenthood of Pennsylvania versus Casey, which is the undue burden standard. It says that states cannot impose an undue burden on that constitutional right that was set out in Roe. And so until June 24, those were the two cases that conferred basically an unenumerated constitutional right to a pre-viability abortion. Dobbs was a 6-3 opinion from the Supreme Court that overruled Roe and Casey. and said that the Constitution does not confer a right to an abortion, and that the authority to regulate abortions is now returned to the individual states and their elected representatives, which means the state legislatures get to decide whether abortion is legal in that state, and if it's illegal, whether it is punished by a civil fine or criminal sanction. There were many concurring opinions and one dissenting opinion in that case that might all be useful for people to read in terms of where, to read the tea leaves, where the Supreme Court might go from here. But that at a high level is the Dobbs decision.
Thanks, Katie. Can you please tell us what you believe are the implications of this decision for criminal prosecutions?
Yeah, the implications of this case are vast, and not just in the context of abortion. I think the takeaway is that Dobbs says that they have returned abortion to the state. But the effect of the opinion is going to be that the abortion wars are going to be waged in courts across the country, both civilly and criminally. So I think as of today, 9 states have now banned abortion and carry criminal sanctions for procuring one. 4 more have bans coming into effect. 8 states have bans that are blocked in litigation already. And then you see a handful of states that are going the other way, that are trying to protect the abortion access that's available in their states and trying to protect women and doctors from out-of-state criminal charges. So I've sort of structured my thoughts on the implications for criminal law into different buckets. One is that the text of the Dobbs decision raises obvious questions about whether any unenumerated constitutional right is safe. That means interracial marriage, the right to contraception, gay marriage, crucially for this opinion, the right to interstate travel. And so if one extends the reasoning in Dobbs, you would not be crazy to think that none of those rights is safe going forward. I think people also need to take the court at their word that they are returning this question to the states. And by doing so, they are returning prosecutorial power to every district and county attorney nationwide. And I think we need to take it seriously when local officials say they will be prosecuting women for murder or attempted murder, doctors for murder or aiding and abetting, aiding and abetting charges for Uber drivers to take women to clinics, to nurses that help facilitate this, to pharmacists who prescribe misoprostol and other abortion-related drugs, fundraisers who support, the funds that assist poor women in achieving these medical procedures. So I think everybody needs to take people seriously when they say they intend to prosecute anyone associated with the procurement of an abortion. So from a criminal defense perspective, I think defense lawyers especially need to be as creative as possible in advising and defending their clients. This includes bringing constitutional challenges to state statutes that ban abortion. Overbreadth, for example, that a statute is unconstitutional if it does not provide sufficient notice of what actually constitutes a crime. And abortion is a very gray area because you have to prove that the fetus was alive at the time you procured the abortion. And there's a lot of questions about when life begins, but also about whether a miscarriage happened before the abortion, or whether it was not an abortion, it was a miscarriage. And so one avenue of challenge to these state statutes criminalizing abortion is going to be that no reasonable person could know what conduct of theirs actually constituted the criminal act. There's a related void for vagueness challenge that defense lawyers need to be prepared to bring. There are also state-based constitutional rights. For example, Montana has an enumerated right to privacy in our Constitution. And so defense lawyers need to be prepared to be constitutional law scholars if they are ever faced with defending someone who's been accused of either homicide or some other crime for procuring an abortion. There are also jurisdictional complications in the criminal law that could potentially help women or doctors who are charged with crimes here. One is that abortions are still, as far as we know, legal on federal land. That can include land where it is not technically federal land, but the feds have jurisdiction. For example, Indian country. It can include federal prisons, military bases, maritime jurisdiction. So that's a wrinkle here that is sort of the reverse of the marijuana laws, where they are illegal federally but legal in states. Defense lawyers need to be prepared to raise supremacy clause or preemption challenges, because right now abortion is guaranteed under federal law when the life of the mother is at stake. And so if someone in a state whose life is at stake tries to procure an abortion and it is illegal to do so in that state, she potentially has a defense that federal law preempts that state law and says that she can have an abortion under those circumstances. There are also very complicated jurisdictional issues about the FDA's rulemaking authority, because about half of abortions in this country are medical rather than surgical procedures. That is, they are achieved by ingesting a course of several different drugs. If an abortion is achieved by drug and not by surgery, there's interesting arguments that the FDA's rulemaking authority about the legality of those drugs may preempt or at least complicate a state law saying just using the term abortion doesn't really tell you whether it's a chemical one or a surgical one. Then there are also these so-called zombie laws that various states have passed that they're not really trigger laws. The trigger laws are saying as soon as Roe is overturned, abortion is now illegal in this state. So those trigger laws have taken effect. But zombie laws are these very weird laws that were on the books that were overturned because Roe said you could not legislate away a right to abortion. And so now that Roe has been overturned, the question is, do these zombie laws resurrect themselves? And so in the context of criminal law, this is another potential challenge to these laws, that they are not procedurally valid, and therefore someone cannot be prosecuted under them. Those are just high-level sort of constitutional issues that defense lawyers need to be aware of. And none of us know how this is going to shake out. And so for criminal defense lawyers, we need to be creative, and we need to be willing to challenge not just well, I mean, we need to be willing to challenge the statutory schemes here and not simply defend our clients against criminal charges. In terms of advising clients, if you have a client who comes to you who has been charged with an offense related to procuring an abortion, there's also, there's a whole separate aspect of ways of potentially defending these cases, including whether the state must prove a mental state. Traditionally, people are prosecuted because they committed a crime and they committed an act and they had the requisite mental state. They intended to do it. Here, for example, if a doctor is prosecuted for aiding and abetting a homicide, there are potentially mental state defenses that he or she was following a Hippocratic oath and was trying to help a patient rather than having the mental state required for this offense of homicide. There are interesting Fifth Amendment privilege issues, because if a woman doesn't tell anyone she's pregnant, anyone but her doctor, can she be compelled to bear witness against herself? Because being pregnant now is presumably an element of these offenses. And if some states have doctor-patient confidentiality privileges, and if you pair that with a Fifth Amendment privilege, there's really good reasons for women to start being secret about their pregnancies. Because they might not be able to be compelled to testify against themselves about the fact of their pregnancy. There are also, I think, for advocacy purposes, criminal defense lawyers need to be advising their clients that there are potentially Fourth Amendment implications for doing things like using really common pregnancy or period tracker apps that are supposed to be anonymous. So, the Fourth Amendment jurisprudence is if you share information in the public, then you don't have a right to privacy over it. You don't need, it's not a search if someone uses that information. Many women use pregnancy and period tracker apps now. And if they are making that data available, can it be used against them in a criminal prosecution? These are the sorts of things that criminal defense lawyers need to be thinking about when they're advising clients. And so I hope I haven't gone on too much, but all of this is simply to say we have no idea how all of this is going to shake out state to state. And some of the frontline people in figuring out how this will play out are going to be criminal defense lawyers.
Thank you, Katie. In the interest of keeping with our time, I'm going to reserve the final question on pregnant incarcerated women. And if we have some time at the end, maybe we can move to that area. Is that acceptable?
Makes sense, Amy.
Great, thanks so much. All right, I'm next going to move to Colin. Colin, are you still with us? There we go, excellent. All right, can you please give us an overview of Shinn v. Ramirez?
Yes, so Shinn is, depending on who you ask, either the sky is falling or just another brick in the wall of the inevitable screwing over of criminal defendants who claim they've either been wrongfully convicted or convicted as a result of a Sixth Amendment violation and effective assistance of counsel. Shinn is the least sexy case of the ones that you're going to hear about today. I guess what I'll tell you is I'm going to give you kind of the International Space Station view of Shinn and federal habeas law. These are the two treatises that sort of are the Bibles of federal habeas law. And believe me when I tell you the font in here is about a 6. So it's dense. The other thing I'll tell you is Shinn is in large part not the court's fault. So if there's anybody out there who's thinking about tracking down Justice Kavanaugh at a restaurant and yelling at him about Shinn, more power to you. But a lot of this really is the fault of Bill Clinton and the Congress of 1996 that passed an act known as Aedpa. It's the Anti-Terrorism Effective Death Penalty Act. So if anybody's undaunted enough to go and plow through the details of Shinn, what you're going to see both in the majority opinion and in the dissenting opinion are different and completely contrasting arguments based on the statutory language of Aedpa. And a lot of that is just the fault of the way Congress wrote the law and the sort of conflicting theories or schools of thought that the various justices have on what that statutory language says. So at the end of the day, without getting too far into the weeds, in order to, if you've been convicted in state court, and I'm actually just going to leave this conversation to state prisoners. If you've been convicted in state court, you get convicted before a jury, you go to direct appeal to the Montana Supreme Court, and then let's say you lose there. Your next option to challenge your conviction is through a state process called post-conviction relief. And if you lose there, you can then appeal that denial to the Montana Supreme Court. And if you lose there, your next step, God help you, is the United States District Court in the district in which you're incarcerated. So that's kind of where Shinn begins. And again, I think one of the things you're going to take away from hearing from all three of these cases, from Caitlin's, mine, and Andy's, is the court sort of pushing back its own authority onto the states. This comedy, we want to have states start having the power to make these decisions. So it's under Aedpa, it's really, really hard to get your claim even adjudicated in a federal court, right? So you go to federal court and you say, you know what, I've been wrongfully convicted because my lawyers suck. They were ineffective. They failed to, introduce a surveillance photo of me in the Sistine Chapel at the time this murder was being committed in Los Angeles, right? And but for the introduction of that evidence, I never would have been convicted. So I'm innocent, basically, or at least there's this, my client sucked enough that he didn't score me an acquittal. So if you're in federal court, it means you've either lost that claim in state court or, oops, my battery's running low. Sorry. So you've either lost the claim in state court or you never raised it in the first place. And if you've never raised it in the first place, that's where you're at in Shinn. There used to be this mechanism, and it lasted for maybe what we in the law would consider a hot second, which is about 10 years. And it was based on two cases. Martinez is just the sort of shorthand version of them, where you could go to a federal court and say, well, look, I know that the statute creates all these procedural bars for me to bring my case to you, federal judge. But I have an out, right? And my out was that my post-conviction lawyer in state court did not raise this claim. So to get into federal court, you basically have to show that you're not time barred or you're not procedurally defaulted. To get around procedurally defaulted, you have to, you can show cause and prejudice, right? I had this great claim and I have cause to show why I didn't bring it in the state court, and I'm prejudiced by the fact that it wasn't brought in the state court. One of those reasonings that got created in Trevino was your state post-conviction lawyer was ineffective. And Shinn basically made that go away. So you had this wonderful sort of out that us habeas practitioners were trying to use. And now what the Supreme Court gave it took it the way. So, yeah, again, Shinn is sort of, from my perspective, the culmination of just an ongoing hose job that the federal courts are giving to federal or to state convicted petitioners. Again, Amy, it's deep in the weeds, right? I'm glad I can't really see anybody but Robin, and thankfully her eyes haven't glazed over yet. But realistically, I mean, this is a dense opinion, and it's based on decades and decades of law, both pre-Aedpa and post-Aedpa. And, you know, honestly, it didn't get a lot of attention. The attention that it did get was sort of, the sky is falling, innocent people are going to get convicted, they're not going to get their day in federal court, and they're just out of luck. And I guess the cynic in me says, well, yeah, that was always the case, and Shinn is just maybe drawing a little bit more attention to it now. There's a couple things that are interesting in the decision for me. One, it was written by Justice Thomas, who was a loud dissenter in the Martinez cases, so he's finally getting his knife back and turning it in. And then there's sort of these weird justifications for why the decision is made as it is. One of them really is that, well, we want to let the state courts handle these things because federal habeas is like a nuclear remedy, right? I mean, it's the federal courts coming in and saying, state courts, you're all idiots. This poor defendant got his rights violated, and we're going to reverse this conviction. And, you know, Justice Thomas and his brethren come in and say, well, that's just really expensive to do to the state, right? I mean, now they have to prosecute this person twice, which is pretty lame when you consider the fact that the defendant / petitioner has brought a claim saying, yeah, my rights were violated. The other issue that I kind of take out of Shinn is this notion that federal habeas relief is an extraordinary remedy. And it absolutely is. But they take extraordinary and say, extraordinary equates to should be used sparingly, if at all, right? There's a constitutional provision that says the writ of habeas corpus can't be suspended. The Supreme Court has said Aedpa does not suspend habeas corpus because you still have the ability to ask for it, which is, you know, great, congratulations. They gave you the ability to ask for a unicorn, even though you don't ever actually get it. So I think it's strange that the court has sort of said, well, extraordinary necessarily means rare or, you know, unavailable altogether. Favorite part, just sort of the gallows humor aspect of Shinn. There's a footnote in it where the court goes on to say, well, because the defendants in Shinn argued that the government, the state, had forfeited certain arguments by failing to raise them at the district court. And that's true. I mean, the state can absolutely forfeit claims, they can forfeit or waive arguments, and so can a defendant. And what the court says is, well, yes, we recognize that, you know, these crappy state court lawyers may have waived this claim before the district court, but we're going to forgive it, right? And so they sort of forgive the state for the same actions that the defendants in Shinn are actually requesting, right? We had bad lawyers, they made mistakes, forgive us. And the court says no, and then in this little footnote, it says, oh, well, we're going to forgive the state's lawyers for failing to raise it. So it's just, you know, one of those little double standard issues. I guess the important thing at the end of the day, and then I'll shut up, about Shinn is not only does it make it increasingly difficult to pursue your innocence claims in a federal court. So not only does it basically shaft the innocent, but it also shafts those who may or may not be innocent, but who have been convicted unjustly or as a result of a constitutional violation by ineffective assistance of counsel.
Thanks, Colin. I have a couple of follow-ups. Can you please, for our folks that have joined us today, spell out Aedpa?
Aedpa. Like spell it out?
No, like give us not the acronym as opposed
Oh,
to.
yeah. So it's the Anti-Terrorism Effective Death Penalty Act, AEDPA.
Thank you.
Passed in 1996 when there was this perception by Newt Gingrich and the boys that crime was running amok, and Timothy McVeigh was going to get off scot-free because of these crafty habeas lawyers. So we needed to crack down on crime. We needed to get tough on crime. They got then President Clinton to sign it. He's since come in and said it's one of his bigger regrets in his presidency, signing that decision, which is actually quite impressive if you recall the Clinton presidency, because there may have been one or two things to regret other than Aedpa, but I'm glad that he says it. And like most of his regrets, he can't take it back. So if you have, really the nice thing about Aedpa is that, the Supreme Court, you don't get to lobby them, right? You can stand out and hold up your pro-life, pro-choice signs all day long, and they can just stand on the top and, moon you. The nice thing about Aedpa is Congress can fix this. And, you can go to your congressman, you can lobby them, and you can say, look, people are getting wrongfully convicted, or innocent people are getting wrongfully convicted. And the federal courts that are charged with enforcing federal constitutional protections are basically saying they don't have the ability to do this because you're a crappy law. Fix it. And Congress can't act. I certainly don't believe that they ever will, but they can. So that's a long answer to an acronym question, Amy.
Thanks, Colin. And I guess just lastly, another clarifying, the case is around ineffective assistance of counsel. And if you could just very briefly give us your definition of ineffective assistance of counsel and how common is it?
I'll actually give you the Supreme Court's definition. It comes from a case, Strickland versus Washington. Ineffective assistance of counsel is basically a two-pronged test. Your counsel screwed up, they erred, and that error resulted in prejudice. So in order to raise an IAC claim, ineffective assistance of counsel, you have to show both error and prejudice, and you have to absolutely show them both. Even if you have an error, didn't prejudice you, you haven't been subjected to ineffective assistance of counsel. How common is it? It depends who you ask. I would say very common. If you asked a defendant, they would say, of course, it's very common. If you asked a court, any court, they would say it's exceedingly rare.
Right.
I do a lot of post-conviction work. I do a lot of habeas work. I can't tell you how many judges have looked at me and said, counsel, would you agree with me there's no such thing as a perfect trial? And as a trial lawyer, I say, of course, right? When I'm in a trial, I'm lucky if I make 10 mistakes a day. And I just cross my fingers and hope that they don't result in prejudice to my client, right? I forgot to object on hearsay. Really, what most courts do when they review an ineffective assistance of counsel claim is, absent sort of a close call, they will essentially just say, okay, we're not even going to address the error portion. Even if we assume error occurred, we're going to just move straight to the prejudice prong. Even if trial counsel screwed up, even if appellate counsel screwed up, the error did not rise to the level of prejudice, which is basically a likelihood that but for the error, the result would have been different.
Thank you. All right, I am going to move on to Andy and discuss the Oklahoma case. Andy, can you give us a brief overview of the decision and what it means for tribal sovereignty?
Yeah, so Oklahoma v. Castro-Huerta is a decision concerning criminal jurisdiction in Indian country, which generally means reservations. And under the normal rules established now for decades and decades, crimes committed in Indian country, if there's a Indian perpetrator or an Indian victim, those generally fall to either federal jurisdiction or tribal jurisdiction to prosecute. And those general rules go back really 2 centuries, quite some time. And under that framework, states have little to no jurisdiction in Indian country when it comes to criminal jurisdiction. So those rules go back, they're rooted in treaties, they're rooted in the US Constitution, they're rooted in state constitutions, which generally disclaim jurisdiction over Indian country within their territories. So that's been the case for quite some time, federal or tribal jurisdiction when there's an Indian perpetrator or an Indian victim. And there's 2 kind of judicially created exceptions, I guess, to that general rule. One is United States v. McBratney, and that's just a case from the 1880s where a Supreme Court said crimes committed between 2 non-Indians on a reservation go to state court. There's really no basis for that decision, but it came down and it's been built on since the 1880s. Another one decision that came out a century later is Oliphant v. Suquamish, and in that case, the Supreme Court said that tribes have no jurisdiction at all, no criminal jurisdiction at all over non-Indians. So that's been the general criminal jurisdiction framework in Indian country for a long time. And compared to civil jurisdiction, criminal jurisdiction has been relatively well established. And you know, there's still some jurisdictional conflicts, but it's relatively settled law. So what happened in Oklahoma v. Castro-Huerta is that a non-Indian, Castro-Huerta, was convicted by the state of Oklahoma for abusing an Indian child. And he appealed that, and his argument was that, well, this occurred in Indian country. Therefore, there's no state jurisdiction because I, as a non-Indian committing a crime against an Indian in Indian country, means it's going to be federal jurisdiction. Because remember, the tribes under Oliphant have no jurisdiction over non-Indians. So it would be exclusively federal jurisdiction. So that would be normally a no-brainer case. There's no state jurisdiction there. And it would be a case that is prosecuted by the federal government. And, you know, that's been, again, established for about 200 years. But the Supreme Court in this case said, no, actually, we're going to make a new ruling in Indian law that state governments have concurrent jurisdiction with the federal government to prosecute crimes committed by non-Indians against Indians in Indian country. So that's a problem for a few reasons. One of which is that it basically flips the normal presumptions in Indian law. As I've said, it's long been presumed that in Indian country, state jurisdiction does not kind of reach into reservations. It's got to be federal or tribal. What the court here said is that, in fact, the presumption is that state jurisdiction does reach into reservations, and they've justified that by saying that reservations are really just part of the state. So that's a complete flipping on its head of 2 centuries of jurisprudence. So they flipped the presumption, and so now the presumption is that state jurisdiction does reach into Indian country. Now the impacts of this, first of all, are pretty broad, because the way Indian law works is that these kinds of cases get built on over the decades. And when you have this reasoning that tribes are just part of state territory and that state jurisdiction presumptively applies, that's going to expand beyond just prosecutions of non-Indians against Indian people. It'll probably work its way into civil jurisdiction cases. It may even expand to include prosecutions of Indians against Indians ultimately, if you take the reasoning at face value. So that's a big problem. That's a big problem for tribal sovereignty. But it's also a problem for wrongful convictions. And here's what I think is an issue is we have gone from relative clarity about criminal jurisdiction in Indian country to the introduction of a totally new framework. So we have 3 sovereigns who potentially have jurisdiction over crimes now in Indian country: the federal government, the tribal government, and the state government. So number one, that is probably going to lead to less clarity as to who prosecutes who for what in Indian country. And what the history there is that when everybody has jurisdiction, they might be expecting everybody else to do prosecutions, and the end result being no prosecutions occur, and you can have problems with lawlessness. The epidemic of missing and murdered Indigenous women on reservations is part of that lawlessness that results from conflicting or overlapping or duplicative lines of jurisdictional authority when no one, in fact, picks up the ball and runs with it. So there's that problem, but there's also a different problem, which is that this case, instead of supporting tribal jurisdiction, instead of basically saying Oliphant is wrong and maybe tribes should just have jurisdiction within their own boundaries over everybody within the reservation, and then we'd have clear jurisdiction and rule of law. Instead of doing that, instead of just clarifying the situation, it introduces another foreign sovereign into the reservation context. So instead of tribal criminal justice systems handling tribal crimes with tribal prosecutors and tribal judges, tribal investigations, you now are going to have, in addition to the federal government, state governments doing it. And the problem there is that I think that could lead to an increase in bad prosecutions to the extent that they happen, because states are very often, and the federal government, very often considered to be kind of foreign governments within Indian reservations. They don't know the reservations very well. They don't know the people there. They don't know how the criminal justice system works on reservations. And my fear is that you may get an increase in bad prosecutions by state criminal justice systems, just because they don't know the context in which they're working. They're not part of the communities in which they're working. So I think that is my fear with this case, is there could be issues both with an increase in jurisdictional lack of clarity and an increase in potentially bad prosecutions.
Thank you, Andy. This was not a prepared question. This is a question that's coming right contemporaneously from me. But can you speak to how this looks different from, say, a public law 280 state, where
Sure.
the state already has some jurisdiction?
So as I was saying, under the normal laws of Indian jurisdiction, it's basically the federal and tribal governments that have jurisdiction for crimes committed in Indian country. Now, there's a big exception to that. There's the McBratney rule, Indians versus, or non-Indians versus non-Indians. Those go to state court jurisdiction. But in the 1950s, Congress passed what's called Public Law 280, which gives specific states jurisdictional authority, both civil and criminal, over specific reservations. So that was a specific act passed by Congress, and it was later amended so that states could retrocede jurisdiction back to tribes. So for example, in Montana, there's only one public law 280 reservation, which is Confederated Salish and Kootenai tribes. And there is some state criminal jurisdiction, but then later on, the tribes kind of took back jurisdiction over misdemeanors and other offenses. So Public Law 280 is a specific act by Congress that applies to specific tribes and in certain contexts. And it was passed in the 1950s at a time when there was a movement to try to increase state jurisdiction. But it's pretty circumscribed and limited to just those tribes and states covered by Public Law 280. This case basically extends state criminal jurisdiction throughout the nation into all Indian tribes. And one of the questions that was raised here was, if it were true that states always had jurisdiction like this in Indian country, then there would have been no reason to pass Public Law 280 in the first place, because Public Law 280 was passed because it was assumed states didn't have jurisdiction and that tribes didn't have the systems in place to handle some of the crimes, and because the federal government really wasn't doing enough law enforcement on the reservations. So this case, Castro-Huerta, basically encompasses and subsumes and makes Public Law 280 almost a non-issue now, since essentially it said state law applies everywhere throughout the country.
So much, Andy. I appreciate that. Is there anyone that has any questions? I don't have any yet in the chat. I think we've got a few minutes, and if there aren't any immediate questions, I'd like to return to Katie for the last question of prepared by the project. But I'll give a moment. We can do a hand raise at this point if the chat's not of interest to you. All right, Katie, are you ready?
Sure. Yeah,
Okay.
you want me to address what Dobbs means for pregnant incarcerated women?
Yes, please. Thank you.
There's a jurisdictional aspect to this because, as I mentioned earlier, abortion is still legal under federal law. And so presumably federal inmates may still have the right to access this procedure. But there is a wrinkle there because there are plenty of federal inmates who are housed in state jails and prisons based on contracts and whether the federal inmate is pretrial or not. And so like with everything right now, the short answer is we have no idea how this is going to affect our clients, but it will matter very much whether they are federal or state inmates and whether they are pre or post conviction. The other thing to keep in mind is that by definition, the population we're talking about here has a pre-existing criminal history since they're inmates, and so they will face enhanced punishment if they try to procure an abortion and are charged with a crime for doing so, because it is usually the case that you face enhanced punishments for committing an additional crime when you are in jail or in prison. And so these women are not only much less likely to be able to procure an abortion because they're incarcerated, but if they are able to request that procedure and it's legal in the area where they're being housed, there's obviously timing implications for them that, the sooner the better in terms of having an abortion. And then there is the additional consideration about whether they face enhanced penalties for the sentence they're already serving if they try to procure this medical procedure and are charged with a crime for doing so. So I think they are a subset of you know, if you take the basket of people that are affected by Dobbs, they are the subset of people for whom this is both incredibly urgent and least likely to be able to get the procedure that they want in the time that they want, and who are most likely to face the harshest penalties if they are charged with crimes.
Thank you, Katie. Appreciate that. So after discussing the cases, and this is for all of our panelists, this feels like a hopeless time for many people. What can those who are watching this panel discussion do to address the issues discussed today, or more broadly advocate for criminal and racial justice during these challenging times?
I'll start. I guess from my perspective, what Shinn is a re-emphasis that every battle that can possibly be fought ever to challenge a conviction, a state conviction, needs to be fought in state post-conviction proceedings. So to the extent out there that you have friends, loved ones, or are a lawyer, you need to just make sure that every conceivable federal, state, rival, whatever, kitchen sink defense needs to be ready to go, fully investigated and fully exhausted in the state court or in the post-conviction process, or 99.9% chance you're out of luck in federal court.
Should I go next? Should I go next?
Please, Andy, thank you.
So I think this case and Dobbs in particular kind of shift focus to clean up the masses created by the judicial branch to Congress. So I think there's going to be a lot of attempts at clarifying these issues and working on these issues in Congress. So that's kind of one shift in focus I think we're all going to need to make and hope happens. And then with respect to Indian country, you know, the fact that there's been civil and criminal jurisdictional conflicts and lack of clarity, especially in the civil context, but now in the criminal context, that's been a reality in Indian country for a long time. And Indian country has figured out how to work with other jurisdictions for the most part through cooperative agreements and things like that to make sure things keep functioning well in Indian country. And I think after this case, after the Castro-Huerta case, there's going to be even a bigger need for that, for local cooperation on the ground. And that's been kind of the history in Indian country in Montana and elsewhere. So I guess if there's hope in all of this, it's that things will continue to function on the ground. And we just need to also continue working for clearer jurisdictional authority for tribes.
Thank you, Katie.
Yeah, I think at least for the Dobbs decision, it really is probably quite easy for people to feel hopeless and for the hopelessness to turn into apathy. And because Dobbs returned abortion regulation to the individual states, I think what that's done is made even more true Speaker Tip O'Neill's comment that all politics is local. What can be done now is staying involved in politics at the local level, redistricting, voter registration, fighting voter suppression laws. These are the kinds of things now that are going to make sure that abortion access is available in your particular state. And that, you know, this will all be litigated, of course, state and federally. But in a way, Dobbs has returned or emphasize the importance of getting involved in politics and in redistricting and in voting at a very local level, because we actually do have the power to make sure in our particular jurisdiction that this remains not just a constitutional right, but a legislative right.
Thank you. I want to thank each of our panelists for their time and their expertise. And I want to thank each and every one of you who are viewing for spending your lunch with us today. We are at our hour, and I just want to remind folks, encourage you and your networks to follow us on social media. We can be found at MTIP Innocence Project on Facebook and at Big Sky Innocence on Twitter and Instagram. Thanks so much, everyone. Have a great rest of your day and a great weekend.
Don't forget the book club on the 29th.
Oh, that's right. That's right.
Wait, let's just hope that they send my book to the right address. You know, I'm moving houses, right? I'm back and forth. I might have to bring crib notes for it, but I'll be there. Bye, everybody. Have a good weekend.
Bye.